is an appeal in the matter of Yodel Delivery Networks Limited and Jacob Corlett and Oars.
Yes.
May it please your lordships, I'm Jack Rivet and I appear on behalf of the appellants Shift Global Holdings Ltd and Corja Holdings Ltd. I was due to appear with Edward Davies, King's Counsel. I understand that he has written to the court.
He has, thank you. Yes.
And I obviously repeat that apology. My learned friend Andrew Thompson, King's Counsel, appears together with Ben Griffiths on behalf of the respondent, Yodel Delivery Network Ltd. Before I begin, have your lordships managed to read the documents on the suggested reading list?
We have, thank you. And we've also wondered how you were proposing to structure your submissions today.
Yes, my learned friend and I have discussed that. We propose that the order of submissions is that I will go first, dealing with my appeal, followed by the respondent's notice. My learned friend will then respond, and then I will reply. And we've agreed that the time will be divided equally between us.
Yes, I mean, the alternative is just to deal with the appeal first, and then we can see where we are, and if necessary, address the respondent's notice after that.
Yes, that's fine by
would that be all right?
In the court's hand.
So it would be appellant's case, your response, and then reply on the appeal, and then, as I say, we'll see where we are, and if necessary. I mean, I don't want to sort of mess up, or we don't want to mess up the structure you've got, but if they're in discrete parts, that might seem to be a more sensible way of dealing with it.
My lords, from my perspective, if the elements that are hived off to the second round, if I can put it like that, are the 2 points about serious question to be tried.
Yes.
That would make, if I may respect,
yes.
sense of perfect sense.
Okay.
Our response notice raises a few other things which are really just for the avoidance of doubt.
It was a serious issue to be tried.
They're better dealt with everything else.
Yep. Okay. 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 Thank you.
Thank you.
Yes.
Yes, thank you, my lord. The background to the dispute is set out in the judgment of the Deputy Judge, which is at tab 9, page 132 of the core bundle. I don't know if it would be helpful for your lordships for me to briefly describe it, or alternatively just to dive straight into my appeal.
Why don't you just briefly describe it?
The dispute concerns the ownership and control of Yodel, the well-known delivery company. And as matters currently stand, Yodel is under the control of another delivery and logistics company called InPost. InPost holds 95.5% of the shares in Yodel's immediate parent company, Judge Logistics Limited, and the remaining shares in Judge Logistics are held by another company called PayPoint. Judge Logistics acquired Yodel last June. Prior to then, Yodel was ultimately owned by Mr. Jacob Corlett. During the period when it was under his ownership, Mr. Corlett executed warrants to subscribe for shares in Yodel to various people, including the appellants. The appellants exercised those warrants in January of this year, but Yodel has refused to comply with them, hence this dispute. So in essence, we're concerned with a battle for control of Yodel. InPost is in effect on one side, and the appellants are on the other. The context for this appeal and the underlying application to which it relates is that InPost only took control of Yodel, of Judge Logistics, and therefore of Yodel in April of this year, the 17th of April. And since then, it has been pursuing a transformation plan for Yodel. I will take your lordships to some of the details of that transformation plan shortly. However, as you see, if fully implemented, Yodel will become unrecognisable. It won't even have the Yodel brand anymore. And those changes will be irreversible. Now, faced with that prospect, the appellants applied for injunctive relief. And the purpose of that relief was to pause the implementation of InPost's transformation plan until the dispute over the ownership and control of Yodel had been resolved. And to minimise any disruption, the appellants also applied for the dispute to be heard on an expedited timetable. That was the application which was heard by the Deputy Judge on the 5th of June. And in a judgment handed down on the 11th of June, he directed that the dispute be heard on an expedited basis, and it has been listed since then with a 7-day estimate and a 5-day window, commencing on the 27th of October. However, the Deputy Judge dismissed the application for an injunction. While he held that the appellants had a good argument case, he considered that damages would be an adequate remedy for the appellants, and he also held that if he was wrong about that, the appellant's cross-undertaking and damages was inadequate, and that the balance of convenience tipped in favour of refusing relief. And it is against that conclusion that the appellants now appeal. And for its part, the respondent has filed a respondent's notice in which it submits that the judge's decision should be upheld, not just for the reasons he gave, but for additional reasons too. So with that introduction, I'll move on to my appeal.
Thank you.
I don't think there is much dispute about the test which is to be applied on this appeal. I've addressed it in footnote 4 of my appeal skeleton. I must show that the judge either erred in principle in his approach, or was left out of account or taken into account some feature that he should or should not have considered, or that his decision is wholly wrong because the course is forced to the conclusion that he has not balanced the various factors fairly in the scale. Now, I accept that that is a high threshold, but in my submission it is met in the present case. The first ground of appeal is that the judge erred in concluding that damages would be an adequate remedy for the appellants, and the judge addressed the question of whether damages would be an adequate remedy at paragraphs 67 to 71 of his judgment, which I'll take your lordships to. It's in core bundle tab 9. I'll endeavour as far as possible to limit the documents to take you to those in the core bundle and the core supplementary bundle. So I fear on occasion I will need to go to the full supplementary bundle. The judgment is at tab 9, page 130, and his decision on the question of the adequacy of damages begins at paragraph 67 on page 148. And the kernel of his decision is at paragraph 70. I invite your lordships to read.
Yes.
Now, with respect to the judge, his reasoning is not very clear in my submission, because at paragraph 70.4, he doesn't address the appellant's submissions as to the loss which they would have suffered if an injunction were not granted and why that loss could be compensated in damages. But of course, that, from paragraph 71, it was on the basis of this reasoning that the judge dismissed the injunction application. So it was central to the outcome of the application. Now, there are a number of problems with the judge's conclusion on this issue. Before turning to those, I should address you on the legal principles. The respondent, for its part, doesn't address the legal principles in its skeleton argument, so I assume that they are common ground, which means I can take them very quickly. We address them at paragraph 16.1 of our skeleton argument, where we refer to American cyanamide and the decision of the Court of Appeal in Alfred Dunhill and Synoptic. And in that latter case, Lord Justice McGraw identified two questions for the court when considering the issue of whether damages would be an adequate remedy for the applicant. And that decision is at tab 9, which is volume 1 of the authorities bundle. And the relevant passage is on page 134.
Yes.
And it begins was next to where the red line starts, with a reference to the American cyanamide principle.
So where does the judgment start?
And the judgment starts on page 97. Oh, the actual substantive judgment of Lord Justice McGraw starts on page 132.
Thank you. Yes, I see. Thank you.
But the passage which I wish to show to your lordships is on page 134.
Yes.
And it's just next to the red line where your lordships will see a reference to the American cyanamide principle. And what Lord Justice McGraw says is, the first factor to be looked at in deciding the balance of convenience is the financial question. It involves, in fact, a number of questions. First, what loss, if any, is the plaintiff likely to suffer if an interlocutory injunction is refused and it subsequently turns out that it ought to have been granted? Next, if there would be such loss, what is the prospect that the plaintiff will be able, in fact, to recover that loss from the defendants after the action has been decided? So there are two questions. Applying those to the present case, so far as the first question is concerned, the respondent, by its respondent's notice, submits that the appellant will in fact suffer no loss if no injunction was granted. That's paragraph 3, little b, little Roman 1 of the respondent's notice. And as I understand it, the respondent's case is as follows. Our claim, the appellant's claim, is to shares in Yodel. The issue, therefore, is whether we would suffer uncompensatable loss in the value of those shares, and they say we wouldn't because the shares in Yodel are presently worthless. Now, in my submission, that misrepresents our case on loss. Our case on loss was one of loss of an opportunity. And the backdrop to that is our underlying claim, which is not for damages, but for specific performance. We want shares, we're entitled to shares, not in any business, but in the business as currently constituted. And the effect of the transformation plan, which InPost wishes to implement, will be to transform Yodel irreversibly beyond recognition into a company which is wholly dependent on InPost. And it might help if I briefly show your lordship some of the features of the proposed transformation plan. If your lordship still have the judgment in front of you, the judgment below, paragraph 67 on page 148.
Yes.
I would invite your lordships to read paragraph 67 to yourselves.
Yes.
And that is, I appreciate the judge was recording Mr. Davies' submissions, but that is a summary of the plan which is proposed. And I believe none of that is controversial, with the exception, possible exception of paragraph 67.7, which is the transformation plan is not for the benefit of Yodel, but for the benefit of InPost. I imagine my learned friend would dispute that. But so far as it summarises what is the intended effect of the plan, that is all derived from the respondent's evidence of Mr. McCourt. And the key point is the extent of the transformation plan, or the transformation which will occur as a result of the implementation of that plan. And in fact, you can see at paragraph 70.2 below that the deputy judge recognised that while the company will continue to exist, it will be in a likely substantially modified form. Now, there are 2 points arising from the underlying evidence which are not recorded in the judgment, but which I would like to show your lordships. The first is from Mr. McCourt's evidence, and I can take that from the core supplementary bundle.
Yes.
Tab 2, page 19. Just to explain who Mr. McCourt is. As he says in paragraph 1, he is the Chief Financial Officer at InPost UK Limited, the parent company of Judge Logistics and the indirect parent company of Yodel. And since the 17th of April 2025, when JLL, that's Judge Logistics, and Yodel became subsidiaries of InPost, he has also become the Chief Financial Officer of those companies too. And the relevant paragraphs are paragraphs 22.5 and 22.6 on page 27. And sorry, I should have introduced that point. If your lordships turn back a page to page 26,
Yes.
he refers in paragraph 21 to something called a summary of the 2+10. And that's the document which he relies upon as evidencing the transformation plan. Or the financial aspects to it. And then he summarises what that shows in paragraph 22. And the 2 paragraphs which I'd ask your lordships to read are paragraphs 22.5 and 22.6 on page 27.
Yes.
And the point I just wish to draw to your attention is that the transformation plan itself, its implementation, will cost a lot of money. We learn that closing depots will involve upfront costs of over £5.5 million. £2.5 million has been budgeted for branding costs. That's changing Yodel's branding to an impost branding. And towards the bottom of paragraph 22.6, we're told that it's going to cost over £25 million in exceptional costs, largely from July onwards, that's this month onwards. So that's all money which would not be incurred if the transformation plan did not go ahead. The second point to draw to your attention is from the evidence of Mr. McCourt's co-director Neil Cushel, which is at tab 3 of the core supplementary bundle on page 52.
Yes.
Page 53, paragraph 1, Mr. Cushel explains who he is. He's the CEO of Impost, Judge Logistics and Yodel. And at paragraph 27 and onwards, he refers on page 59.
Yes.
And he refers, there's a heading, Impost efforts to turn Yodel around. And he refers to the transformation plan, which Mr. McCourt will be dealing with. And it's really paragraph 28 to draw to your attention.
Yes.
So from Mr. Cushel's perspective, the transformation plan is ambitious, it is not easy, and it involves risk. So even on the evidence of Yodel's own CEO, there is no guarantee that the transformation plan and the costs which Yodel is incurring in implementing it will bear fruit. So stepping back, the evidence in my submission shows this. First, if the warrants claim succeeds, it follows that the transformation plan should never have been implemented because we should have been already in control. And Yodel has incurred costs of at least £25 million, which it should not have done. That is a cost which will plainly affect the value of the appellant's investment in Yodel. It is a cost which the appellants, as the rightful owners of Yodel, will need to fund somehow. Secondly, the business of Yodel will have been transformed beyond recognition if Impost is allowed to implement its plans in full. And that transformation will be irreversible. In particular, Yodel will have lost its distinctive brand. Not only will its business have been merged with that of Impost, it will be dependent on Impost for revenue, given its new subordinated role as a subcontractor of Impost. Further, its business will have moved away from providing indoor deliveries to providing locker deliveries like Impost. It will have lost depots and employees, and it will have cost Yodel £25 million to do all of this. The end result will be that if the warrants claim succeeds and specific performance is granted, the appellants will become the majority shareholders in a company whose business is entirely dependent on the cooperation of Impost, which in this scenario will be a minority shareholder, and presumably a disgruntled one at that. And the appellant's ultimate objective, which is to merge the business of Yodel with Shift, will be completely impossible. Therefore, the loss to the appellants if an injunction is not granted is substantial, and I would say unquantifiable. At the very least, it's the cost of covering the £25 million which Yodel will have spent. So that's the first question which the court has to address when considering whether damages would be an adequate remedy to the appellants. Let's say it arises out of the way it's put in the respondent's notice. The second question, turning to my appeal, is whether the appellants will be able, in fact, to recover that loss from the defendant after the action has been decided. And even if the appellant's loss is capable of being quantified, it's quite clear that Yodel could not pay even a nominal amount of damages. And in fact, this appears now to be common ground, because Impost is now proposing to give a guarantee to the appellants, by which it will guarantee payment by Yodel of any damages awarded in the appellant's favour. Now, that offer was made for the first time in paragraph 40 of the respondent's skeleton argument. For that reason, it was not addressed either by the judge below or in any of the evidence filed in relation to the applications. And it's since been followed late on Tuesday evening with a copy of the draft guarantee. Now, my submission, it's obviously telling that Impost...
Sorry, do we have that? I don't remember seeing a copy of the draft guarantee.
No, it's not in the bundles, my lord, but we've got copies, of course, if the court would like to see it.
Now, my submission is obviously telling that Impost feels compelled to put forward that guarantee, but it doesn't actually help them. At first, there is no proper evidence that Impost could actually discharge its liabilities under the guarantee. In its skeleton argument, the respondent asserts that Impost is plainly in good financial standing. However, that submission is not borne out by its last published accounts. Those accounts are at tab 20 of the supplementary bundle.
Do you remember which file that is?
Yes, it's file 5.
Sorry, tab 20, did you say?
Yes, sorry, tab 20, page 2721. These are its annual report and financial statements for the year ended 2023. Those are the most recent published ones.
Yes.
And on page 2734, this is the statement of comprehensive income, and you can see its loss for the year 2023 was just under £40 million. That's slightly better than the previous year, but it's still an enormous loss. And on the following page of the balance sheet, that shows net liabilities of just under £126 million, which is significantly worse than the previous year. Now, Mr. Cushel has provided some new evidence on this. It's not it's evidence which has been produced by the respondent and has not yet, as I'm aware, been formally admitted into the court, but we have no opposition to it.
Good, yes.
It is to be found in tab 10 of the core supplementary bundle. And this is Mr. Cushel's second statement, beginning on page 131.
Yes.
And at paragraph 23, Mr. Cushel, there's a heading Impost Guarantee.
Sorry, which page do you want?
Sorry, it's page 137.
Yes.
And Mr. Cushel, he towards the bottom of the paragraph talks about the financial statement, and he says he doesn't actually address squarely Impost's financial position. In fact, what he says is Impost operates with the benefit of an assurance from its parent company, InPost, forgive my pronunciation, Pak Komati. The latter will support InPost for at least 12 months following the approval of the latest InPost financial statements. Just pausing there, that assurance doesn't provide us with much comfort. First, we don't know the terms of any assurance. Secondly, on the face of this evidence, it is discretionary and time limited. Thirdly, and more importantly, we have no idea about the financial standing of InPost Pak Komati. What we're then told is these companies are part of a wider listed group whose latest audited consolidated financial statements showed shareholders' equity of over, some 556 million euros and cash equivalents of over 181 million euros. And that is a single page document which appears at page 142 of the bundle. And that's most obviously what it doesn't show, of course, is anything about InPost Pas Komati. It's a single page taken from the wider group statements.
Do you mean that you take it that the company referred to, although it's identified as parent, is not the ultimate parent?
No, as I understand it, the ultimate parent of the group is called InPost SA.
I see.
Now, it would have been a simple matter for Mr. Cushel to have provided us with specific information about InPost UK Limited and about InPost Pas Komati, but he doesn't. So instead, we're left completely in the dark as to whether they could discharge any liability under the guarantee.
Do you know in what jurisdiction these companies are incorporated, Pas Komati and SA?
I assume that Poland. My learned friend will be able to clarify that.
Incorporated in Poland, listed in Amsterdam.
I think SA is.
So the offer of a guarantee is of absolute...
Just before you
I'm sorry.
leave that, I see that there's an exhibit. What does that tell us? That's a consolidated.
That's just the single page. Well, it's 2 pages to include the cover page.
So if one were to look at the consolidated position, there's lots and lots of money available.
Yes, but we simply don't know what it is. It's not the whole group which is offering to support InPost UK Limited. It's a specific company within that group. And as I say, the offer of a guarantee is therefore of no comfort. To the contrary, the fact that InPost is compelled to make such an offer reinforces our submission that even if they were capable of being quantified, damages would not be an adequate remedy for the appellants. And the second reason why the guarantee doesn't help the respondent is that even if the appellant's loss were quantifiable, and even if InPost were able to compensate them for that loss, the offer of a guarantee does not address the second of the appellant's criticisms of the judge's approach. And that criticism arises as follows. If the warrant's claim succeeds, the appellants will be the majority shareholders in the respondent. But the respondent will also be on the hook to pay damages for any loss suffered by the appellants as a result of the fact that no injunction was granted. Now, clearly in that scenario, the appellants will not be compensated by the payment of damages by the respondent, its subsidiary. To the contrary, that's going to prejudice them. And that's because if they enforce their claim to the damages, it will obviously affect the value of their investment. But if they forego their claim to damages, they'll be left out of pocket. So it's a lose-lose situation.
Has not Mr. Cushel addressed that point in paragraph 23?
Well, what he says is that they will have no recourse to Yodel in respect of any sums paid under the guarantee. So as I understand it, what's being said is that if InPost is forced to provide money under the guarantee, InPost won't then seek to recover it from Yodel. But that doesn't alter the fact that Yodel will remain the primary debtor.
So why will that matter if you've got the money from InPost?
Well, the question is whether or not we need to go against Yodel first before we can go against InPost. Because the guarantee, of course, is normally only a secondary liability.
You don't normally need to sue the primary obligor first. You can go against the guarantor, and then
Well,
the guarantor, if the guarantor chooses, can normally go against the principal debtor. But here, the guarantor has said they won't.
But it's a form of secondary liability, my lord. So it's only engaged if there's default by the person who's primarily liable. So Yodel would still, in any event, Yodel would still be in principle liable for that sum. It doesn't remove its liability. It may be that we can, if it defaults, go against someone else and recover our money, but Yodel would still be on the hook.
But you can deal with that by asking Yodel to pay the money and procuring that Yodel say no.
Yes, my lord, I see that. But of course, it doesn't deal with our primary concern, which, of course, whether impost is in any event good for the money in the first place.
It really comes back to that
It
point.
does. I accept that is the principal concern. So, my lord, to conclude on ground one, then, of the grounds of appeal, in my submission, the judge ought to have held as follows. First, in the event that no injunction was granted, the loss which the appellants would suffer would be unquantifiable. But secondly, even if the loss was quantifiable, the appellants would not be able to recover that loss from the respondent, at least not without prejudicing the value of their investment in the respondent. So, my lords, that's all I had on ground one. I was proposing to move to ground two. The second ground of appeal is that the judge erred in concluding that the undertaking offered by the appellants was inadequate. And the judge dealt with this issue at paragraphs 72 to 79 of his judgment on pages 150 to 152 of the core bundle behind tab 9. And his actual decision on this issue is at paragraph 77 to 78 on page 152. And I invite your lordships to read those paragraphs to yourselves.
Yes.
And as you can see, the focus of his decision was on the appellant's lack of resources. What he didn't actually address was the extent to which Yodel would suffer any loss if the injunction were to be granted. That was an error. And to make good that submission, I'll first address you on the law before turning to the facts. Now, the starting point, of course, is that an applicant for an injunction is ordinarily required to give an unlimited cross-undertaking and damages. That's expected as a matter of fairness, and the appellants have offered to provide that standard cross-undertaking and damages. They're willing to put all their assets on the line in return for an injunction. However, when it comes to assessing whether the proffered cross-undertaking and damages is adequate, the court necessarily has to consider the loss which the respondent might suffer if the injunction is granted. And that point is demonstrated by the decision of Mr. Justice Mann in Sinclair and Cushley, which is at volume 1 of the authorities bundles, which your lordships will find, in fact, we'll find it at tab 17 of volume 1 of the authorities bundle.
So just to clarify, you say the appellants are willing to give an unlimited undertaking.
Yes.
Is that Shift and Corja, or is that Mr. Corlett as well?
No, it's just Shift and Corja. They're the two appellants. They're the two applicants for the injunction.
That's what I thought.
Yes, it's tab 17 at page 307.
Yes.
And the judgment starts at page 308. Paragraph 1, your lordships will see that there were two applications before the court. First, it was in substance an application, the effect of which was to seek fortification of a cross-undertaking and damages. And the second was an application for security for costs. Turning forward, if your lordships turn to page 311 of the judgment, paragraphs 10 and 11 are headed the state and status of Sinclair, which was the claimant.
Sorry, tell me again. Which-
Paragraphs 10 and 11 on
Thank
page
you.
311. I'm afraid it hasn't actually been marked with a
Don't worry.
line, but it's those paragraphs. I invite your lordships to read.
Yes.
And as the judge concluded in the last sentence of paragraph 11, the picture in that case is the claimant who has no tangible assets, who is very arguably insolvent, whose shareholder is in effect unknown, and so far as FHC can be described as a financial backer, whose financial backer is with completely unknown solvency. Then at paragraph 12, Mr. Justice Mann summarised the application before him. And in short, the defendant was concerned that the cross-undertaking, against the background of the claimant's financial position, the cross-undertaking damages lacked value, and therefore he applied for it to be fortified. And the sum which he sought by way of fortification was €750,000, which your lordships will see on paragraph 16. Now, the arguments in opposition to that application were summarised at paragraph 17. On the bottom of page 313. And you can see that, you also see there are three arguments which were raised in response.
Yes.
Now, the judge dealt with the first and third of those grounds of opposition at paragraphs 18 to 21 of his judgment, on pages 314 to 15. In short, he dismissed those. But then he dealt with the second issue from paragraph 22 onwards on page 316. And I invite your lordships just to read paragraphs 22 to 25, the ones marked with the sideline.
Yes.
Before I come back to those paragraphs, just to complete the picture, in paragraphs 26 to 31, Mr. Justice Mann went on to assess the evidence which the defendant had adduced, and he concludes at paragraph 32.
Yes.
On the 319, I find that Mr. Krishna has not demonstrated a sufficient level of risk or potential loss as a result of his undertaking respecting of the letter says. For that reason, I declined to order the fortification sought. Of course, while the focus of his decision was on fortification, it necessarily follows the judge must also be satisfied as to the adequacy of the cross-undertaking and damages. And that's despite the fact, as we saw before, the claimant had no tangible assets and was very arguably insolvent. Now, there are a number of points just to pick up from the passages I invite you to read. The first is that in determining whether a cross-undertaking is adequate, the court has to form a view as to the kind and degree of loss that may result. We see that from paragraph 22 of his judgment. And secondly, the question of whether a cross undertaking is adequate and whether fortification is ordered are really two sides of the same coin. And the connection between the two is demonstrated by the passage from the judgment of Mr. Justice Millett in Re DPR Futures Limited, which is cited at paragraph 22, where he says, just above the emboldened passage, if the value of such an undertaking is considered insufficient in any particular case, he should be required to fortify it. So if the court considers that the cross undertaking is insufficient, it doesn't just dismiss the application, it requires the claimant to put up fortification, or at least give the claimant an opportunity to do so. And the third point to take from the judgment in Sinclair is that a submission that the cross undertaking lacks value must be supported by evidence from the defendant as to the risk of loss. Now, on that last point, please I take your lordships to the decision of Mr. Justice Calver in National Bank Trust and Mints, which is at tab 29, page 579 of your authorities bundle. It's volume 2.
Yes.
Now, this was an application for additional fortification. Your lordships can see that from paragraph 1 of the judgment on page 582. And the claimants had previously been ordered to provide £2 million of fortification. In fact, you can see that from paragraph 11 on the bottom of page 584. And Mr. Mintz was now asking for additional fortification in the amount of £20 million, $20 million, sorry. Now, paragraph 26, Mr. Justice Calver dealt with identified the principles concerning fortification of undertakings. I invite your lordships to read that paragraph.
Sorry, how far do you want us to go?
Well, it was paragraph 26 initially, but then I was also going to show you some parts of paragraph 27 as well, where Mr. Justice Calver fleshes out some of those requirements.
Right.
And the first is, in relation to the first requirements, can the applicant show a sufficient level of loss? That's in Little Roman 1 on page 590. I'd like your lordships first to read that.
Yes.
And then in relation to the second requirement, Little Roman 2, for our purposes, it's paragraphs, subparagraphs A to D on page 591, which are relevant.
Yes.
Now, we've just underlined while we're here what is said at the beginning of subparagraph D on page 591. which is if the loss would have been suffered regardless of the granting of the injunction, for example, because of the bringing of the proceedings, then that is not covered by the undertaking. And then finally, on page 593, related to the third requirement, Roman 3, is there sufficient evidence to allow an intelligent estimate of the quantum of the losses to be made?
Yes.
Just to pick up a point in paragraph 26, which I meant to do, which is just to observe that it's for the applicant for fortification to show a good arguable case for it. The applicant in that scenario must be the defendant or the respondent to the injunction.
That's why I wonder whether this is rather the wrong way round. I mean, when you're asking for an injunction, the court looks at the risk of uncompensatable damage to the applicant. And then it looks at the risk of uncompensatable damage to the other party.
Yes.
It doesn't at that stage have to engage in whether it would be appropriate to order fortification, does it? It asks, is there a risk of uncompensatable damage to the respondent?
I accept that, but in answer I'd say two points. The first is the principles which the court applies when assessing whether fortification is required, the ones I've just shown you, are a suitable test for determining whether or not the cross-undertaking in damages is adequate, because they go to the question of, as Mr. Justice Mann put it, of is there a sufficient level of a risk of loss? That's how the court should assess it.
Plainly, it's right to think about whether there's a risk of loss, but some of this seems to be very specific to fortification and doesn't seem on point. I mean, I quite follow, if you're going to ask fortification to a figure, you have to think about the figure.
Yes.
But it's not quite the same if you're asking yourself about risk of uncompensatable loss more generally.
Well, in my submission, respectfully, I'd say that it is, because when you're trying to assess whether the cross-undertaking in damages is adequate or not, one necessarily has to look at what is the actual loss to the respondent from the proposed undertaking. So it's the same question which arises both when assessing whether the cross-undertaking in damages is adequate, which applies when assessing whether or not fortification is required. And in my submission, that was the point which was raised by Mr. Justice Mann in the Sinclair case, where he says, well, with or without fortification, is there a sufficient level of a risk of loss? So it's precisely the same questions which have to be asked. And of course, going back to the 2 points I had in response, the second point is the reality is that if a defendant or respondent, to an injunction says that the cross-undertaking is inadequate, then it almost follows as a matter of course they're applying for fortification too. That's what happened in this case. That's what you would do. And it's borne out, again, by the comments of Mr. Justice Millett in the Reed DPR case, where he said, if you recall, I drew it to your attention, where he said, well, if the cross-undertaking is inadequate, then the applicant should be required to provide fortification. That was a 1989 case, and obviously the principles have been more developed there, but at least it seems to me as clear from 1989 that, as I say, the cross-undertaking and damages and the question of fortification were really two sides of the same coin. So in my submission, before the court could dismiss the application on the basis that the cross-undertaking and damages is inadequate, it needed to be satisfied as to three things to the standard of a good arguable case. First, the Yodel had showed a sufficient level of a risk of loss. Secondly, that the loss had been...
Let me just get this down. So
Sorry.
it needed to be satisfied to the level of a good arguable case.
Yes.
First.
The Yodel had showed a sufficient level of risk of loss. A sufficient level of risk of loss. Secondly, that the loss had been, or has been, or is likely to be caused by the granting of the injunction. And thirdly, that there was sufficient evidence to allow an intelligent estimate of the quantum of the losses to be made. And it was only if Yodel discharged the burden in respect of each of those questions that the court should go on to consider the appellant's financial status, so as to determine whether or not the cross-undertaking was adequate or not.
Why do you say the burden's on Yodel?
Well, I take that really from the way in which it's put in paragraph 26 of Mr. Justice Calver's judgment.
But that's where there's an application made by the respondent.
You're correct, which of course was the case here.
But it's not the case when we're considering whether you should have had your application for an injunction granted.
Well, as I said, there are two really questions with the cross-undertaking of damages. The first is the one which is a matter of fairness, which is whether one should be given in the first place. And in nearly every case, of course, it's expected that it is given. And the appellants did that. But then there's the question of whether or not the cross-undertaking is adequate. Now, at a pure practical level, that's not something which the appellants can answer. We could speculate, but in reality, the only person who can answer that question is the respondent. And if they want to say, well, the injunction, the cross-undertaking and damages is inadequate because of all the loss we've suffered, it's for them to demonstrate that. Now, when I was turning to the facts of the present case, I entirely accept that at paragraph 78 of the judgment on page 152, behind tab 9, I showed this passage to your lordships before, that in the middle, the judge says, no fortification has been offered by Shift or Corja, whose obligation it is in my judgment to offer it in support of what is otherwise a worthless cross-undertaking. My submission that was wrong. It's a matter of law. And then secondly, insofar as is necessary, I'm satisfied that Yodel has shown a good arguable case of fortification, and that his evidence, and particularly that of Mr. McCord, does satisfy the criteria relevant to the exercise of the court's discretion to order fortification. The difficulty is there is absolutely no explanation in the judgment as to how the judge reached that view. And in my submission, if we look at the evidence, there was no foundation for it. Now, the evidence relied upon before the judge was Mr. McCourt's first witness statement. That statement is behind tab 2 of the core supplementary bundle. And the relevant part of his evidence on this question is at paragraph 30, starts at paragraph 39, on page 33, under the heading Impact of an Injunction on Yodel. And he first refers to the restrictions which the company would face as a result of the injunction. And then he deals with the financial impact in paragraph 42, which I invite your lordships to read.
Yes.
And it's in fact the figure of £33 million in paragraph 42.2, which is put forward as an argument, and in fact in paragraph 16 of Mr. McCourt's second witness statement. It's the 33 million at the end of paragraph 42.2. And as your lordships will see, what Mr. Court says about that is he says, well, it's the average actual losses suffered by Yodel in March and April 2025. They were about £5.5 million per month. And if you extrapolate that forward to cover the 6 months between the date of Mr. McCourt's statement and the date of the trial, one arrives at the figure of £33 million. That's how we get to that figure. Now, just pausing there, it can be seen that those are not losses which are attributable to the injunction. They can't be, because there is no injunction. And in fact, the injunction hadn't even been mooted at the time when those losses were incurred. But in response, what Mr. McCourt says, well, those losses could be avoided if InPost is allowed to put in place its transformation plan for the business. And that's why the appellant should be responsible for them if an injunction is granted. So effectively he says, if Yodel could not make further improvements to its business. So the prospects of InPost's transformation plan are central to the respondent's case on loss. Now, I've already shown you what the transformation plan involves. You recall it involves changing the nature of Yodel's business, novating contracts to InPost, making employees redundant, closing depots, discarding the brand at least a cost of £25 million. And given the extent of it, it's perhaps unsurprising that Mr. McCourt's co-director, Mr. Cushel, acknowledged that it was ambitious, not easy, and involved risk. So Mr. Cushel, at least, has some doubts as to whether or not that transformation plan will succeed. Now, the only information which we were provided in support of that plan, as far as the financial ramifications of that plan, is a presentation which your lordships can find at page 42 of the core bundle. It's very hard to read the numbering because it appears on the picture.
Sorry, page 42 of the core bundle.
Yes, page 42 of the core bundle. Oh, I'm so sorry. It's a core supplemental bundle.
Yep, thank you. Yes.
Now, this is the plan to which Mr. McCourt refers in his statement, the 2+10F plan. And you can see from the middle of the page that it is marked draft for discussion only. So it's not even a final document, it's simply a draft. And it's also incomplete. So if your lordships turn to page 44 of the core supplementary bundle,
Yes.
you might be able to see, it's quite possibly quite hard to see, but you'll see a large number of 2267 in the bottom right-hand corner. That's actually...
Sorry, which page?
It's page 44 of the core supplementary bundle.
Sorry, I'm looking, yeah.
And you'll see if you turn it so that the document is landscape, you'll see there's a big red number 2267, which is just the pagination from the supplementary bundle. But just above that, you could see a little number 5.
No, completely. Page 44,
Yes,
the middle number,
yes. If you turn the document onto its...
I have.
Yes, and then you'll see in the bottom right-hand corner of the document.
2267.
Yes, and just above that, can you
Yes.
see a tiny little number 5?
Yes.
Internal page.
That's the internal page number.
Yes.
Exactly. I could have
Got
probably
that.
got there faster
Sorry.
by saying
Yes.
that. Sorry. So we know that's page 5 of the document.
Yes.
Turn over, then we see it's page 6.
Yes.
Turn over, then it leaps to page 35.
Yes.
Over, it leaps to page 37 with a lot of redactions. Then it jumps to page 40. And then finally page 42.
Yes.
So assuming that the document is only 42 pages long, we've only been provided with 7 pages, a number of which have been redacted. And on top of that, we have no idea who the author is. And particularly when one reviews the document, it's quite hard to make sense of what it's saying. However, it might be helpful just to show your lordship some of the assumptions which it makes. So if we go back to page 44 of the supplementary bundle.
Yes.
There are two tables, one which says pre-IFRS 16 2+10 forecast. That's the top table, which is a sort of salmon pink colour.
Yes.
And then there's one below, which is the post
Yes.
figures. And it's the top table which Mr. McCourt deals with. That's the one numbers which he's always referring to. And if we were to just focus on the bottom line of that, you can see that it provides a monthly breakdown of what the EBITDA is going to be pre-IFRS 16.
Yes.
And in the beginning of the year, we have a negative 10.4, negative 7.5, March is negative 8.2, and so forth, up until June, where it's negative 6. And then in July, from this month, it's going to be break even. And then it gradually, same again in August, and then it's slightly profitable, September, October, and November. So these are the forecasts of the effect of the transformation plan. So purely on the basis of that sudden improvement in performance, that looks like an ambitious plan, precisely as Mr. Cushel said. But I'd also ask your lordships to keep in mind, in particular, the prediction of break even in July. Because if we provided with an update of sorts on the financial figures in Mr. McCourt's statement, and this is his second statement at tab 9, page 123 of the core supplementary bundle. And on page 129, paragraph 16,
Yes.
Paragraph 16, perhaps if your lordships want to read that to yourselves.
Yes.
So you'll recall the evidence we just saw, that the position before the judge was that as a result of the transformation plan, Yodel would be break even in July. So we're now told that it's going to suffer an EBITDA loss of 3.3 million in July. And notably, we're not given the actual figures for any of the months before July, nor are we given estimates for the months after July. All we are told is that the company remains significantly loss-making. So in my submission, the court can place no confidence in the respondent's evidence, such as it is, that if an injunction were granted, it would suffer losses to the tune of 30 million odd, which would otherwise have been avoided by its transformation plan, because its own evidence suggests the contrary. Now, it's not just the transformation plan on which Mr. McCourt relied in support of his case on loss. He also relied on the potential loss of customers, and his evidence on this is at paragraph 44 of his first witness statement, which is at page 34 of the core supplementary bundle.
Can I go back to paragraph 43?
Yes.
These losses will need to be funded, and to keep Yodel trading as a going concern will need to be funded by somebody.
Yes.
So if there is an injunction, what's the impact of that on the funding prospects?
Well, it's, in my respectful submission, a matter for impost. It's a commercial decision for them as to whether or not they wish to fund it.
What would the possibilities be? I mean, if they're absolutely confident of success at the trial,
Which they claim to be.
but nevertheless stymied in going ahead with their plan now,
Yes.
they have to make a decision, do they, as to whether it's worth ploughing money in?
Yes.
Suppose that they think there might be something in your case, then it's an even more difficult calculation. So what happens if they think well, we better not take the risk of plowing more money in?
Well, in that case, really, first of all, it'd be a matter for the directors of Yodel as to whether or not, what to do in those circumstances and whether or not there are other sources of funding available, as to which we don't know. If there aren't any, and ultimately it's completely dependent upon Impost to carry on funding it, well, then that's simply a commercial question for Impost.
So
So it's nothing to do with injunction, it's just, it's their decision.
they might just let the company fold.
They might just let the company fold. But that would be their decision. It wouldn't be caused by the injunction.
Well, it would be, wouldn't it? Because they'd have been put in the position where they had to make that decision.
Well, they're put in that position to make that decision because of the claim, which is different from the injunction.
Well, we
Because-
know that the mere claim hasn't stopped them going ahead and ploughing money in. So it would be the injunction that would be making the difference.
But my lord, that's exactly your point, though, isn't it? Which is that if they think there is something in the claim, and that causes them to stop the funding, then that is an issue which has arisen by virtue of the claim, not by virtue of the injunction.
But we know that the claim alone hasn't stopped them putting the money in. So it would be presumably the injunction or the injunction combination of the claim that would cause the trouble.
Well, I worry that that's, in some respects, too speculative, because the fundamental concern which they would have is, as I understand your lordship's question, is there a risk that once this trial has been determined in October, early November, that the warrants, the claimants will get specific performance and will no longer be in control? Now that is a risk which already exists. It's there, and they have not stopped. In fact, they knew from January, I think possibly even earlier, that from December, about the existence of these warrants and the fact they were going to be exercised. And it's from that date onwards that the bulk of the funding has been put into the company. So it hasn't stopped them yet.
The injunction will stop them from carrying on with the transformation plan. They will lose the benefit of doing that during what they refer to as the peak season, which is very soon going to be upon us. And they would be faced with the certainty that they won't be able to revive the transformation plan for some months, i.e. until they get a judgment. Or possibly even if there was any question of an appeal, I don't know.
And in my respectful submission, those points would have some force if we could see from the transformation plan that it was going to have the results which they claim it will. But I've shown your lordships the evidence on that, which shows that so far it is not working. The company is still loss-making, even though on its own, the assumptions which were put before the judge, by now, it would already be working.
Well, the plan identifies at least one important chunk of revenue coming in December from a customer who is named, which they say would not be forthcoming if they are not able to rebrand in the way that they want.
Is that a reference, my lord, to the very group?
Yes.
The very group. Well, if we look at the evidence on that, it's slightly more nuanced than that in my submission. I don't know if it'd be helpful to show your lordship what's said there. It's in tab 10, sorry, it's Mr. Cushell's statement.
I was really giving that as an example of one aspect of loss which they say they would suffer, and while there may be nuances which you're about to show us, you accept, I think, that all of these things only need to be shown to a good arguable case standard. So we're not dealing in certainties.
Well, that's true, but we are dealing, of course, it's not just a question of showing there's a sufficient level of loss. We're also doing questions of whether they're caused by the injunction, which I appreciate is the point your lordship was making, but also what is the estimate of that loss? What is the actual consequence going to be of that not occurring? And that was the point as well, was part of the point. I mean, it's very closely related, I appreciate, to the question of a sufficient level of loss. But that was the point I was demonstrating by reference to the assumptions which they have placed before the court at first instance, compared with the evidence they have now, which is that it's impossible to have any estimate of what this loss is. They may say they suffer something, but what is it? how they calculated it. What is the impact not on the impost group but on Yodel itself from not being allowed to pursue this transformation plan? If one looks at the very group in particular, as I say, it presents a slightly more nuanced picture in my submission. If your lordships would like to look at what's said there, then let's, the Lord has raised it. It's at tab 10, page 134. And it goes over to page 15, sorry, page 135, paragraph 15.
Yes.
And so what he begins to say, well, is he talks about the Very Group, which is described as one of Yodel's largest customers. And then in paragraph 13, he provides an update on what has happened with the Very Group. And what has happened is that based on his discussions with them, the Very Group has in fact ended its contract with Yodel, which had been due to expire in 2 years. So he's ended it 2 years early. This is the director of Yodel who's done that. He's also a director of Impost, it's important to point out. And he's replaced it, he's managed to persuade them to replace it with a new 5-year contract with both Impost and Yodel, although Yodel is a party to the contract only for the purpose of entering into various waivers and releases in relation to its now terminated previous contract with the Very Group. And then he says, well, whilst the new contract is primarily with Impost, Yodel will benefit significantly from this arrangement as the 2-door volumes will be subcontracted by Impost to Yodel. We have no idea, he doesn't flesh out what that means. What proportion of the contract is going to go to Yodel? When is the subcontract being entered into? What protections does Yodel have, what has it lost by reason of entering into this replacement contract? The closest we get to is what he says in footnote 3, where it says TVG's previous contract with Yodel envisaged approximately 13 million parcels being processed by Yodel per contract year. However, as a result of the shortcomings in Yodel's service, the Very Group only in fact provided around 10 million parcels per contract year. And if we look at paragraph 14.1, the number of parcels which is now expected to be processed by Yodel is 9 million. So it's dropped by 1 million under the new arrangements. And those new arrangements are not ones which are directly between Yodel and the customer. They're ones in which Impost has inserted itself into the middle of. So one assumes that Impost is getting some benefit from that, which might otherwise go to Yodel. And so on the basis of that evidence in my submission, the risk to Yodel of losing customers and business appears to come not from an injunction, but from Impost. Now, our case before the judge was that the respondent's case on loss was just a theory, and that essentially the entire projected losses for the company going forward could be eliminated by Impost's transformation plan. We submitted that was simply just a theory which lacked any substance, and that there was no evidence to support it. And in my submission on the evidence which has emerged subsequently, it is now clear that we were justified in that submission. Turning back to the principles set out by Mr. Justice Calver in National Bank Trust. First, is there a solid, credible evidential foundation that the claimed loss has been or will be suffered? And in my submission, absolutely not. The evidence relied upon by the respondent is extremely weak. Secondly, can the respondent show to the standard of a good arguable case that the loss has been or is likely to be caused by the granting of the injunction? Again, no. The respondent will continue to be loss-making, irrespective of whether an injunction is granted. Thirdly, is there sufficient evidence to allow an intelligent estimate of the quantum of the losses to be made? And again, no. Their suggestion that their losses would be at least £30 million on the basis of historic monthly losses is, in my submission, discredited by their own evidence. We have nothing on which to make an alternative assessment of the loss. They've not provided any figures or evidence. Now, returning to the judgment, none of this was actually addressed by the judge. Rather than addressing the first question of what, if any, loss the respondent would suffer if an injunction were granted, he jumped straight to the second question, which was to consider Schiff's financial position. In my submission, that was an error. If he had adopted the correct approach, he would have held that Yodel had not demonstrated a sufficient risk of loss, and the financial status of the appellants would have been irrelevant, as it was in the Sinclair case. And even if the judge was satisfied that Yodel had demonstrated sufficient risk of loss, the judge ought to have identified the amount required by fortification as part of the estimate of the loss. For those reasons, my submission, his judgment on that question cannot stand. And because that's all I propose to say on ground 2. As I informed my learned friend this morning, we don't pursue our appeal the judge had inadequate regard to the financial status of Shift. Now, the appellant's final ground of appeal relates to the balance of convenience, and the judge dealt with this at paragraph 80 of his judgment, which is at tab 9, page 152 of the core bundle. And the relevant paragraph is paragraph 80, which I invite your lordships to read. And as you can see, the judge made essentially 3 points, and I'll address each of them in turn. The first point, judge's first point, was that the injunction sought would require Yodel's directors to subordinate their decision-making power on those matters set out in the draft order to Schiff and Corja, and that this would go beyond preserving the status quo. Now, in terms of what we meant by preserving the status quo in the present case, I appreciate your lordships will be very familiar with the judgment, but it might be helpful just to see how the point was addressed by Lord Diplock in American Cyanamid, which your lordships will find at tab 7 of volume 1 of the authorities bundle.
Yes.
And it's the paragraph, the last full paragraph of the page, and next to the letter G. I'm afraid, once again, I'm sorry it hasn't been sidelined, but it's
Sorry, which page again?
page 88.
Thank you.
If there are other factors.
Yes.
And the point which Lord Diplock was making was, if the only effect is to postpone the date at which the defendant is able to embark upon a course of action which has not previously found it necessary to undertake, and that's the marker of the status quo. Now, with that in mind, it might be helpful to show your lordships the relief which the appellants were seeking, which is set out in the judgment at paragraph 36, which is in tab 9 of the core bundle, page 140.
Where did you say it
I'm
was?
sorry,
I might
it's
be in the
pa-
wrong place.
It's the.
Or is in the judgment?
It's in the judgment.
Oh, I see,
Yes,
yes,
it's
I'm
quoted
sorry,
in the
yes.
judgment. I'm sorry, it doesn't appear to have actually made its way into the bundle, unfortunately. But
Sorry, if you look at what Lord Diplock said, he was first of all saying embarking on a course of action which not previously found necessary to undertake, and the second is to interrupt him in the conduct of an established enterprise would cause much greater inconvenience to him, since he would have to start again to establish the. So we have an established enterprise,
if that's a reference to Yodel, then yes.
and both parties agree that the established enterprise is such that it requires transformation in order to continue in existence. And there's a
Correct.
competition between whose transformation.
Yes.
So it's seeking to interrupt the respondents in the conduct of an established enterprise.
Well, no, because we were trying to stop that transformation plan.
I understand that, but that's interrupt, isn't it?
No, my lord, not if it hadn't begun. I mean, they only took control of the company in April, and the injunction was issued in early May. And in any event, there are certain aspects, of course, of the transformation plan which we regard as crucial, which haven't yet been implemented, such as the rebranding.
Yes, paragraph 36.
Paragraph 36 sets out the relief which we received.
Yes.
And the starting point to note in paragraph, at the bottom of the page, paragraph 5, that the claimant shall not conduct its business otherwise in the ordinary course. So we weren't trying to interrupt the ordinary day-to-day affairs of the company. That would remain.
Does that include the transformation?
No, it doesn't. That's we regard as extraordinary actions, which are the actions which we sought to prohibit in the sub-paragraphs which follow. And you can see that most clearly from sub-paragraphs F to I.
What's the director supposed to do if they have a genuine belief that the transformation plan is in Yodel's best interests?
Well, if they're faced with an injunction which says that they can't do it, then that's an answer to the question.
Well, how can they continue if they're required to do things
Because in that,
they believe are contrary to Yodel's best interests?
well, because it wouldn't be in Yodel's interest to breach a court order. Was my submission. And I would say that trumps pursuing the transformation plan in that scenario. And of course, one point which has been taken against us is the idea that somehow we were seeking to intervene because of the words "without the consent of the applicants." And that, in fact, was the opposite to what was intended. That carve-out was specifically designed to enable, to answer my Lord's question, to enable that if there were something which needs to be done, it could be done consensually and quickly. And that did happen. During the period when the Yodel gave undertakings, there were a number of occasions where the consent mechanism was invoked successfully.
So if you just look at A, incur liability outside the ordinary course of business, your contention would be that everything to do with the transformation is outside the ordinary course of business.
Yes.
Everything. So any transfer of money from Impost to logistics to Yodel would be outside the ordinary course of business.
Yes, well, let's particularly focus on the 25 million which is needed to fund the transformation plan. That would be plainly outside the ordinary course of business. It's a sum of money.
Your clients would have to give the consent to that.
Yes.
And would it be in or outside the ordinary course of business to borrow money from Impost to sustain the company over the coming months?
Well, in my submission, it perhaps sounds stark, but it would have to be. I mean,
Outside the ordinary course of business.
yes, because when one is considering what's considers the actual background to this injunction, we say we should be in charge. We should be the majority shareholders now.
Well, that doesn't address the ordinary course of business.
No,
Point.
but I'm just explaining how I get to my final point, which is that how can we then allow a company to incur vast amounts of debt without knowing its terms? Particularly if we say we in October or November find ourselves in charge and are having to find a means to fund that debt. For all we know, this is an intra-company debt as well. It's not a commercial lender. It's its parent company.
Which I'm assuming is so. I don't know if that's true, but so we know, don't we, that the company is likely to make losses over the period of an injunction.
Yes.
It doesn't have the money to fund those losses.
No.
So if it's to continue to trade at all, it's got to borrow money from somebody.
Yes.
But it couldn't do that without coming to you for your consent.
Correct, my lord. And it's worth recalling
Which you won't give if it's from impost.
we have given it already.
I thought you just said you didn't want them to continue running up debt.
Well, I think it's in an uncontrolled way. That was our concern. But during the period when the undertakings were in place, impost said, "Will you consent to us providing further funds?" And we said yes. So it's not just window dressing. This has actually, the consent mechanism was invoked during the short period it was in place, and we consented to it.
But I thought your submission was that you weren't being placed effectively as though you were in control of the company, and this sounds rather like it. If you have to agree to transactions which are required in order to maintain or sustain the business.
Yes, I see that. Really the point is that the injunction is designed to protect the business so far as possible. Our starting point is to protect it so as to ensure that we have our remedy for specific performance when we get it in November is a real one. We get the business which we originally subscribed for shares in. And now one option was simply just to impose a flat injunction, to seek a blanket ban on any of these actions being taken during the period leading up to the trial until it's been determined. What we proposed instead was, no, we appreciate that's not realistic. So the idea of the consent mechanism, as I say, it wasn't designed to give us a means to interfere in the day-to-day management. It was actually designed to have its purpose was the opposite of that, which is allow these steps to be taken without the respondent having to come back to court every time to ask for permission to vary the injunction. It was supposed to be a means to make this more palatable rather than unpalatable, if I could put it that way. And if there was an objection to these points, well, then the answer to that was we could have listened to what my learned friend had to say about these points and come back with an alternative proposal as to how we might manage it. But that didn't happen.
The injunction, as drafted, gives you an absolute veto. It says without the consent of your client. It doesn't even say not to be unreasonably withheld. But that wouldn't solve the problem because you'd be rushing to court every 5 minutes saying, can we do this and can we do that?
And if we were being unreasonable, my lord, we would bear the consequences of that. I mean, that would be we would be subject to the obviously due process if we're found to have unreasonably refused to give our consent.
Basically, you'd be putting the court in the position of running the company.
As I say, my lord, it was really, I see the theoretical risk there, but when one looks as to what actually happened in practice, that isn't what happened. In my submission, it wouldn't be what happened.
Well, things may be very different when you're still coming to court to ask for an injunction from what they may be after you've got it in your pocket.
Well, I see that too, my lord. Of course, it also is worth bearing in mind that it's only for a very brief period of time. Well, 2 points. Firstly, it's for a brief period of time. We have an expedited trial, so it's for a period of 3 months. It begins, I think the listing window is the 27th of October from now. This is a short period of time. That's the first point. The second point is, as I say, these are matters which, if that was the concern, then we would have made efforts to address them in a way which satisfied both the respondent and the court.
And it's a short period of time, but it's a period over which the company does, what was it, 60% of its annual business?
That's towards the end of the year.
So that's the period which would be impacted, isn't it? Until you get a judgment after
Yes, I wouldn't want to. I wouldn't want to guess as to how long the judgment would take. I can see that in theory it might well not arrive before the Christmas period. I do see that. But it's also worth recalling that that's not the only restriction which we were seeking to impose. That's only one of the heads of relief we were seeking. Let's say the other ones were, well, as I said, the particular ones which I drew attention to were in paragraphs F, G, H, and I. Take H, for example, alter the branding of Yodel. Why is that something which can't be agreed to pending the determination of the trial? Transferring parts of the business to impost. Again, why can't that be agreed to? Transferring customers, in G. Now, these aren't ones which involve impost putting its hand in its pocket and us interfering in the right of the directors to raise money. These are just, my submission, fairly benign restrictions, which are purely designed to make sure that if the claim is vindicated, there's still the business which we want at the end of it.
I mean, I do follow the way you put it, but just looking at the big picture a bit differently. Impost on the face of it is prepared to put its money where its mouth is and plough in a lot of money. One would think on the basis that they think they can turn the business around through doing that.
Yes.
You are seeking to stop them proceeding with that plan, from which one might infer that in their view there will be financial consequences. One financial consequence presumably is that Yodel ends up owing them a lot more money, but Yodel can't pay it, and supposing you have won, then it's not much comfort for them to have a claim against Yodel. And you're not seeking to persuade us that there's any great financial substance behind the cross undertakings. So it rather looks as though they are being asked that you're asking us to prevent them proceeding with something that they can be thought to believe is going to achieve a financially better outcome in circumstances where they can expect to have a bill that you won't be able to pay.
Well, there are two, risk to repeat myself, there are two, my submission responses to that. The first is that they went into this with their eyes wide open. They knew about the warrants when they started injecting money into this company. They knew about it from at least January, I think possibly slightly earlier than that. And from the evidence, the majority of the money which they have lent to Yodel, I think it was 25 million, was lent between June and December, at a time when they were not the indirect parents, when they were simply a third party. And then the remainder has come since January, so since the date they've known about the warrants.
Well, you put it as a choice. Why is it a choice?
Choice, sorry, my lord.
Because the company needs funding.
Well,
So,
they could have, my point is that they knew that there was this dispute on the horizon. They knew that the third parties were saying that they were entitled to majority shareholding in that. And yet, despite that, they proceeded to lend the money. They didn't have to do that, but they did that.
Well,
so they can't then, sorry.
You might argue about the amount they had to lend, but they did have to lend money because it's loss making. But Yodel can't fund the losses or can't continue in business without without being funded. I thought that was common ground.
But it is common ground, but it doesn't have to be from Impost itself, didn't have to be the one who stepped in to do that. During the period when the company was under Mr. Corlett's ownership, it was loss making and they found money to fund it.
So just pursuing that for a moment. So suppose you've got your injunction, claims proceeding. Impost, on this hypothesis, is not expected to find the money itself. So Yodel has to find the money elsewhere. Well, no lender's going to think it's going to get good security from Yodel, as I understand it. So who's going to provide something that is going to tempt a lender to provide money?
Well, that's a question really for after the trial, my lord.
But what about the interim period where you have to fund this operation?
Well, I mean, that is a question for the directors of Yodel as to how they source it.
They can ask Impost to put up the
Yes,
money, but you say, well, Impost might choose not to. money is available elsewhere. So where else might money be available?
I mean, I would be speculating, my lord. I don't know. There's no evidence as to what other sources of funding there would be available. But there have been other available sources of funding in the past. This company has not suddenly become loss-making. It's been loss-making for some time. So there's no. I would push back on any suggestion that it would be impossible to find alternative sources of funding.
Being sold for £1 doesn't exactly instill confidence in its ability to find funding.
Well, at least 2 or 3, I should say, entities obviously place value in it, InPost and my clients. But also, so ultimately, the objective of the injunction was really to ensure that there was a Yodel company operating under its brand by the time the trial is decided. And if the sticking point was over the funding, then that is one aspect of the injunction. It is not the whole. It doesn't represent the entirety of the relief which we were seeking.
Sorry, you were dealing with balance of convenience.
Yes, well, in fact, I think during the course of that discussion, we may have dealt with, in fact, all the points which which the deputy judge addressed, namely the question of subordinating decision-making power of the directors, incurring vast debt, and his final point was, well, the transformation plan already underway does, on the evidence in my judgment, have a prospect of turning around Yodel's fortunes that should not be restricted. And that is, I addressed that point in the course of my submissions about whether or not the cross-undertaking damages was adequate or not.
Well, another point which he put into the balance was that there was, though you said you wanted to have your own transformation plan, there was no evidence about how you were going to carry that out, and in particular how you would be able to repay the company's debt, and that remains the position, doesn't it?
Well, it does, my lord, save for one point, which is, in my submission, that's an irrelevant consideration. Because that consideration only...
Judge entitled to, when he's weighing the balance, to say, well, on the one hand, I've got an ambitious plan with a lot of risk, but it is being carried out, and people obviously have sufficient confidence in it to be actually ploughing in a lot of money to make it happen. And on the other side of the balance, I've got nothing.
Well, there are obviously two points to that. The first is, well, we're not in the position to do anything about our plans for the business at the moment because we're not in control. So InPost can't rely upon the fact that it is doing something and ploughing a lot of money as a point in its favour because we're not there to be able to pursue our own. That's the first point. The second point is the question of balancing of what happens after the trial. I mean, on that hypothesis, the judges effectively were saying, well, that even if you win, it would be better for you to have had the InPost plan there. It would, even if the injunction was, let's say, the injunction was properly granted, and because your claim to the warrants was vindicated. Well, even if that all turned out to be correct, I think it's better for you if InPost is allowed to pursue its transformation plan. And in my submission, that's overstepping what is an appropriate consideration.
But all this must, on any view, go, mustn't it, to the risk of uncompensatable loss to the respondents, in the sense that they don't have the comfort that if you win at the end, I suppose they have to win. Yeah, I withdraw this remark. I don't think I thought it through.
They were the points on the grounds of appeal. I was going to turn to the terms of the injunction at that stage.
Sorry, turn to
the terms of the injunction, which
right.
we're seeking from this court, which are in the appellant's notice. They begin somewhat unhelpfully, they're split across 2 pages. They start in section 9 on page 8. In fact, rather than taking you there, in fact, effectively it's exactly the same as the injunction I've just shown you. So, sorry, that was a bit of a waste of your time. But it's the same as before.
It's the same as in the order.
It is,
I mean,
yes.
in the judgment.
It is. Sorry, my notes hadn't anticipated spending so much time on the terms of the judgment. But one point I would emphasise to your lordships arising out of that discussion is just because there are concerns about one aspect of the relief which we're seeking, it doesn't follow that other aspects of the relief which we're seeking can just be dismissed. Now, there are 2 points arising out of the respondent's notice which I should just address. The first point they make is they say effectively that any injunction now is too late. The transformation plan is underway and it's irreversible. Now, of course, we're not in a position to test that evidence. We just have their word for that. However, what is clear is that the transformation plan is not yet complete. And we know that from Mr. Cushell's evidence, who says they're on track to complete the plan by the 1st of September. That's taken from his second witness statement, paragraph 11, which is in the core supplementary bundle, tab 9, page 126. And so my message is not too late. There is still something to be salvaged, not least the brand. And the second point which they make.
Sorry, I'm just.
So yes, it's at paragraph 11. It's on page 126 of the core supplementary bundle, tab 9.
Yes.
And the second point which they make is that any cross-undertaking and damages should extend to Judge Logistics. And that's on the basis that Judge Logistics is a very large creditor of Yodel. Now, that's not a basis for singling out Judge Logistics for special treatment. Yodel has lots of creditors, and Judge Logistics shouldn't be given preferential treatment over them. And in any event, the creditor, his capacity as a creditor of Yodel, it of course has the indirect protection of any cross-undertaking given to Yodel. Sorry.
No, not at all. And my lords, that's all I have to say in support of my appeal. So unless I can assist you further, I will sit down. Thank you very much. Yes, Mr. Thompson.
My lords, thank you. I'll deal obviously just with the appeal
Yes.
at this stage. It should be dismissed. It faces numerous insurmountable hurdles. I know we're not dealing yet with serious question to be tried, but ultimately to succeed, they have to succeed on that question and also damages not being an adequate remedy for the appellants, and on the adequacy of the cross-undertaking, and if we ever get there, ultimately on balance of convenience as well. They've got the full range of hurdles to get over. As my lords won't need reminding, of course, it is a high hurdle for them appealing the exercise of the discretion by a first instance judge, particularly in relation to an application for an interim injunction. And we refer to the Hamilton case on that. I think supposed to waste everyone's time going back over that. But the short point is that they have to show that the exercise of discretion is based on a misunderstanding of the law or the facts, and neither is the case here. Second, my lords, I should just remind my lords, of course, that the judgment was given under conditions of extreme urgency. On the basis of application for expedition of the application by the appellants. So it's hardly appropriate for them to come along and criticise, to the extent they do, any terseness in the reasoning of the judge, and make that the foundation for an appeal. The judge produced the judgment with exemplary speed under the circumstances. Now, my learned friend reminded my lords, of course, of the background. I'd just like to add one thing to that, which I would say a lot about if dealing with serious questions to be tried, but it's relevant more generally. That is the remarkable nature of the underlying transaction here. My lords have seen this from their submissions, but just a reminder that these warrants purportedly granted options to Shift primarily, but also to Corja and to others, which were exercisable in the event that the proposed merger between Shift and Yodel that Mr. Corlett was pursuing in the first part of 2024 failed. And in the event that after that there was a transfer of ownership of Yodel to a third party. And what they purported to do was to allow those parties collectively to subscribe for shares denominated as 1/100th of a penny, so that they could acquire in number 71% of the shares in Yodel. And that would allow them to swamp, as a matter of numbers, the holders of the 908 million £1 shares that had already been issued. So it's quite a remarkable transaction that has been put forward here. Effectively, it's a form of poison pill, really. We don't need to get into that, but it's just worth reminding my lords of what we're looking at here. Now, on the basis of that transaction, of course, they are inviting the court to grant them an interim injunction. Now, it's also worth pausing in my submission and noting that this is actually rather an unusual injunction they seek. We accepted, and we continue to accept, that there is jurisdiction to grant such an order, but only to be exercised with great care, because this is not an injunction that seeks on an interim basis to restrain something that's alleged to be wrongful, in the usual way. The American Salaried principles, of course, directed to exactly that situation where the claimant says, wrong is being done to me, I'm going to seek an injunction at trial, in the meantime I want an interim injunction to stop it. This isn't the case at all. They are claiming specific performance, and they say, well, because that would give us a majority shareholding, or at least a controlling shareholding, that we ought to have injunctive relief to hold the ring in the meantime, but not to restrain anything they say is wrongful. They're not saying any of this is wrongful or unlawful. They're seeking to restrain transactions which would be perfectly lawful in order to hold the ring so they can pursue their claim.
Well, they do say that you're interfering with their rights of ownership, and that you are affecting, in ways they don't like, the value of property which you ought to already to have recognised belongs to them.
Well, they say they'd be entitled to a majority shareholding so they could control the company. But they're not saying that there's anything wrongful in the transactions that the directors wish to pursue. They're not often what one is doing, for example, is complaining and saying, well, there'd be a breach of fiduciary duty or something of that sort. Nothing of that sort said here. So it's an unusual form of injunction. We entirely accept there's jurisdiction to grant it, but we do say it needs to be considered with great care because of what's been sought.
So while I'm about it, can I just be clear about who you're appearing for? You're appearing for Yodel.
And JLL in order to seek extension of the cross undertaking to JLL.
So that's the purpose for which you're appearing
Yes,
for
indeed.
JLL.
InPost isn't strictly speaking a party. My learned friend, of course, is right in commercial terms that, of course, at the moment, the company is indirectly controlled by InPost. And one might get this sort of contest in other circumstances where there's a shareholders dispute and a Section 994 claim, for example, where you do have the shareholders on either side, as was the case in that Gelato decision. But that's not the decision here. Now, the other relevance of the fact that it's unusual injunction of this sort, it's not, strictly speaking, the asylum principles don't apply, but we're perfectly happy to deal with this on the basis of their useful way of identifying relevant issues. But strictly speaking, they don't.
Does it make any difference?
Well, no, because we say we win either.
You're happy to be guided.
But it's unlikely to make any difference. But if applying the principles does make a difference, then the fact is they don't, strictly speaking, apply. I think it's fair to say these days it's recognised they're not a straitjacket anyway. So,
if Simon, it doesn't apply, what do you say is the governing principle?
well, ultimately, what's just and convenient, it's therefore perfectly sensible to use the assembly principles as a guide through, but not as a straitjacket. I don't want to get too high up on this because I'm not suggesting it actually makes any difference, but I flag it because it's an important feature. Now, turning then to the grounds of appeal, if I may. I mean, the first one is the argument that arises from the judge's finding that damages would be an adequate remedy for the appellants. Now, in relation to this, my lords, the notice of appeal actually just raises 2 points. And I'll deal with those. They are first criticisms of the judge based first on the argument that there was doubt as to Yodel's ability to satisfy the damages claim, which the judge didn't take proper account of. And secondly, the point that they say, well, because Yodel would, if they're right, be majority owned by the appellants, then in any event, a damages claim against Yodel wouldn't be adequate for them. Those are the 2 points they take. And if I can just invite the court to look at the appellant's notice, which is at page 31 of the core bundle, and you'll see that. This is basically the first paragraph of the grounds of appeal, subparagraphs 1 and 2. Those are the 2 points they take. Now, my learned friend in his oral submissions did rather stray beyond that, to the extent that he was making submissions about the type of loss and it appeared to be suggesting that it was uncompensatable. But that's no part of his appeal. In terms of the 2 questions that he identified in the judgment of Lord Justice McGraw on the Alfred Dunhill case, his appeal relates to the second question about the ability of the respondent to pay, not to the first question as to the nature of the loss. So I'm afraid he's restricted to the 2 points that he makes in notice of appeal. So I'll deal with those. Now, as regards the question of whether the appellants would suffer any loss, if no injunction were granted, but they win at trial, we say one has to focus here on the nature of the claim. It's a claim that they're entitled, they say, to shares. And so any loss that they could recover in this action would be in relation to the value of those shares. They can't look through to Yodel and make a claim that's based on harm that they say might be suffered by Yodel. They've got to identify loss to them as putative shareholders. So that's why we invite the court, and we invited the court at first instance, to focus on the question of the effect, if any, of the lack of an injunction on the value of the shares. Is there any prospect of uncompensatable loss of that nature? And the answer is no. The short point is that these shares are currently worthless. Putatively, these putative shares are currently worthless. Now, we've seen that the company was transferred for £1 in February 2024, and then again 21st of June 2024. And since then, it has incurred an extra £168 million of debt. And that's Mr. McCourt's statement of paragraph 28.2.
168, do you see? 168.
168, yes.
Sorry, what was the reference for that?
That's the court 1, paragraph 28.2. And of course, if there is an injunction granted, the loss making will continue, so that figure is going to go up. So the point is, if there is an injunction, the shares are going to remain worthless, and there's no prospect that the value is going to improve.
Does that not rather beg the question? I mean, they say that they have a plan. They think they can transform this business. Why should we assume that they're wrong about that?
Well, I think I'm going to come on to this, but I mean, it's accepted this is effectively a binary choice, and the evidence is that actually, I'll come on to this a lot later, but actually it's really rather too late. But if you go back to early June when this was heard, it was a question of one or the other. It's common ground that there needs to be transformation, there needs to be integration with another business to save the Yodel business, and really it's a question of which business it should be integrated with. And so if there's an injunction, then that the current process that's being pursued will be paused. If there isn't an injunction, the reorganisation will go ahead. And I should also say that we haven't seen any plan whatsoever from the appellant as to how they would do it, nor indeed any plan as to how they would even get to the starting gate by repaying the at least £168 million that would have to be repaid to get them to the starting gate. So actually, in any event, their suggestion of a reorganisation they're going to pursue is just in truth fiction. It's extraordinarily unlikely. There's no evidence that it could actually be done.
But you say, well, look, there's no question of loss because these shares are worthless.
Yeah.
They say, we have a plan. We can make these shares valuable. Well, that would be loss, wouldn't it?
Well, only if the injunction would stop them doing it. And if they could.
Well,
if they could
in reality, it does, doesn't it? Because you say this process is already irreversible, but at any rate, there's a very good chance that by the time judgment is given post-trial, your plan will have been implemented. Their plan will not be a possibility. So if it is the case, we suppose, that their plan could result in giving value to Yodel, that would then have meant that they had shares that had value. More than that, this is a unique asset. That's why specific performance is available. And you would have frustrated that.
Well, we would say that's theoretically possible, but it is purely theoretical in the sense they would have to show that actually, but for the lack of an injunction, they would actually have been able to successfully pursue their plan. And I emphasise they haven't actually identified any basis for thinking that they can do it anyway. So theoretically, yes, but it's purely theoretical. On the evidence, there's no prospect of that.
Let's take their worst case, which is that actually they don't have a plan. Either they never did or they did, but it's now too late for whatever they were planning to do. They do have at least the ability, if they succeed at trial, to frustrate your plan. You obviously think there is money to be made in this company because you're ploughing millions into it, or your parents are. So even on a worst case, their ability to frustrate your plan has some value.
So a ransom value.
Well, possibly.
Yeah,
possibly.
Well, again, theoretically. But
I'm not saying that's the case, but I'm just saying if that's the very worst.
I understand the Lord's point completely. Yeah, but in that case, again, that's a theoretical prospect. We would say because they'd have to show that their ability to extract a ransom would have been lost as a result of there being no injunction. Now, of course, if they were to win at trial and we pursued our plan, well, they might still try to extract a ransom. Virtue of having become, on their case, majority shareholders. So it's very likely to make any difference. So yes, one can.
Well, not if you're right and it's become irreversible.
Well, they would still be majority shareholders according to them. So they'd have to show there was a difference in their ransom, respectively different ransom positions, and it had made a difference. So yes, of course, theoretically, one can imagine ways in which there could be a difference, but in the real world, particularly in the absence of any evidence from them, it's purely theoretical.
I mean, in the real world, supposing they win at trial, it's going to be a mess, isn't it? Because you will have gone about integrating Yodel into your business, into your in-post business, and then they own the company. But the company is loaded with debt.
Well, I don't want to go down a rabbit hole here, but they would have 71% of the shares by number. They would then argue that they're entitled to 71% of the votes. They also appear to be taking a position that they would be entitled to 71% of all distributions and by way of income and capital. And that's actually extremely unlikely because, in fact, they would have paid, I think it's less than 1% of the total paid up share capital. And so actually under the articles, they'll only be entitled to less than 1% of distributions. But my Lord's suggestion that it's a mess is hard to completely refute. I haven't thought it all through, but it would no doubt give rise to some tricky issues. But there we are. Now, but in terms of the probability of the likelihood of any loss to them, it's extremely unlikely. Now, even if I'm wrong on the adequacy of damages, that's still a very relevant consideration when it comes to balancing convenience, particularly when one compares it to the inevitability of uncompensated loss in a very large figure that we would suffer. Well, that's for later, but I'll just lay down that marker now, if I may. Now, then the second answer we have to this, as you've seen, is the guarantee. Now, if they were to be able to recover in relation to loss arising from the lack of an injunction, they would do it by way of a claim for additional damages in addition to specific performance. If they didn't get the specific performance, obviously the injunction wouldn't have been wrongly granted, so they wouldn't get off the ground. So the additional damages. Now, in relation to that, I'm not for a moment conceding they're entitled to anything at this stage, but that would be the mechanism by which they would make such a claim. And so what we've offered is to guarantee any such liability that has been caused by the lack of an injunction. And that's the effect of the guarantee. We can hand it up. You've seen from Mr. Cushel's statement the basic thrust of it. So what it's proposing to do is to meet the two objections that are the two grounds of appeal here by saying, right, well, InPost will guarantee, so you don't have to worry about Yodel's ability to pay, and it won't seek recourse against Yodel. So the fact that you, the appellant, say that in this situation you would be the majority of shareholders isn't problematic because Yodel isn't going to pay indirectly either. And that's a complete answer.
Just briefly there, I think in your skeleton you said if needs be, but this is an offer you make, this is an offer that the court can accept.
Oh yes, the court. Yeah. If the court say, if the position of the court is, well, look, with that guarantee, you're right, then we give it. We will give it. Now,
I mean, you'll show us the terms of what you're offering at the moment, but at the moment, all we know is that it's from a Polish company somewhere in the InPost group.
I'll come to that. Oh yes, can we just hand up copy of what we sent to the Loan Defence solicitors a couple of days ago.
Does this include an offer to submit to the English jurisdiction and an address for service here?
Right.
Thank you very much.
I'll answer that in a moment.
Thank you very much.
Agreed. The Court of England should have exclusive jurisdiction. And so if one looks at if I could just invite the Court to look at the recitals, it's recital C in particular, as it identifies what it is that is going to be guaranteed. It reflects what's said in Mr. Cushel's statement.
But it's now an English company which is the guarantor. Which it wasn't
Yes.
before.
No, it is. The foreign company is standing behind the English company. So Impost UK
Oh, I see.
is the indirect shareholder because it owns most of JLL. And it's giving the guarantee, but it has the backing of the Impost group. I'll
Sorry, I just remembered there isn't actually anything formal or direct from the Polish company.
That's right. I will come on to that in a moment, Lord, if I may. But
Yep.
just to deal with what the guarantee actually covers, if one looks at recital C on the first page of the guarantee,
Yes.
it's in the event that the creditors are successful in their warrant claims and they're granted specific performance, because otherwise they haven't won, pursuant to the warrant document. And three, the company is also ordered to pay the creditors damages together with interest, that they're defined as damages, and then the guarantors agreed to pay, shift to Corja, as the case may be, any guaranteed losses on the terms set out in the guarantee. And guaranteed losses are that portion of the damages that have been sustained from the date of this guarantee, because obviously it must be damages sustained going forward as a result of the injunction, which would not have been sustained if the injunctions had been granted. So we're looking at the any losses going forward, the element of the damages that they might get. They get damages sustained from the date of the guarantee, or the date of the effectively it's going to be the date of the order, which would not have been sustained if injunctions had been granted. So that precisely covers loss that would arise from injunctions not being granted.
I mean, just talking about it for a moment, I can see one or two questions. This, of course, is just a recital, so maybe the body of it makes it clearer. But you, in this hypothesis, wouldn't retain control of Yodel. So what happens if an order is made for specific performance and enforced? You lose control, and then Yodel agrees to submit to a judgment.
But at that point, on this hypothesis, Yodel's under the appellant's control.
No, quite. And you're agreeing to pay the losses, pay the damages.
Well, they're not going to be able to recover twice. But I'm
No,
sure.
no, but what I mean, this is the point that I just wonder whether you're at risk. Yodel, when no longer under your control, accepts that it's liable for an immense amount of damages. Are you guaranteeing that?
Oh, well, I mean, the quantum of the damages will be fixed by way of ceiling, at least, by the court's order, and then the sub-issues as to when the loss arose, and therefore whether it falls within the definition of guaranteed losses, and whether it's actually loss that wouldn't have occurred anyway.
So it would be little two there that would be crucial.
Yeah, but we're only guaranteeing that, and it doesn't matter what. Yodel can't, under their control, force us to pay more than we've agreed to pay here. So I appreciate my lord's point, but I think we're not exposed to excessive risk there. But we think that precisely covers the loss that's relevant for present purposes. Now, as recital D on the first page holds, the guarantor operates with benefit of insurance from its parent company, Impost Axomati, and the latter actually will extend that assurance to at least 23rd of December 2026. So currently it's 2025, to the end of 2025. And for this purpose, we're saying to the end of 2026, just in case that's relevant. That's when these issues are sorted out in the guarantees court. We don't know when the judgment will be. Now, this sort of assurance, of course, is absolutely commonplace in a large group of companies, whereby parent companies give assurance in order for the accounts to be signed off on a going concern basis. and they can be relied on. And the InPost Paxomati is a parent company. Now, the top company, as Moylan correctly said, is InPost SA. That's a Luxembourg company, and it's the one that's listed in Amsterdam. So it, uninstructed, is also perfectly prepared to give that same assurance of support for InPost UK. And so one can look, therefore, at the evidence from the consolidated accounts that Mr. Cushel has exhibited, that my friend showed you, which is right at the end of supplemental bundle file 5, 27692770, and gave reassurance on that, because that does show, as Mr. Cushel describes, in this context, enormous assets.
Is that different from the documents in the core supplementary bundle? What
I don't think so. No, this is the consolidated statement that Moylan
how many pages is it?
It's just 2 pages.
2 pages. The first one being a picture.
Celebrating 25
Yes.
years.
Yeah. It is the same
And
one.
then there's the consolidated balance
Yes.
sheet.
It's page 142 of the.
This is in zloty. This is, Mr. Cushel has done the conversions for us in his statement, the paragraph 24 that you saw earlier, and the 2.45 billion zloty net assets converts to 576 million euros, and the cash of 772 million zloty converts to 181 million euros. So it's a lot of money, more than ample to provide reassurance to the court and indeed to the appellants.
Why not just have that company give a guarantee?
It might have been simpler. Instructions? We'll get instructions. It's not something I can.
No.
But my expectation is that we can do that. We'll get instructions. So we
I mean, I see that assurance is nice, but guarantees are nicer.
yeah. I accept. My submission is the assurance is quite good enough, particularly in the context of the lack of any real fear of uncompensated loss. But we will try and do better.
I agree with my lord that a guarantee from the ultimate parent would really be the preferable thing, but if you are not able to get those instructions, you did say that the ultimate parent was prepared to give the same assurance.
Exactly. I have instructions.
Would you provide, please, a wording which gives effect to that so that we can see what exactly is being offered?
So, yes, we'll do that as well.
But preferably that won't arise because you'll get better instructions.
Absolutely, my lord. Thank you. We'll do that. We'll do both those. Whatever one is necessary. Now, so that really deals with that point. But I just emphasise in passing. Well, even if the court is concerned about the adequacy of damages, it's still everything else is a highly relevant analysis of this. Now, if I may, I'll move on to the question of the adequacy of the cross undertaking. And as you have heard from another friend, they're no longer pursuing one of their 3 points they made in their spelling argument on that.
Thank you.
They are accepting, or at least they are not challenging the judge's finding that their cross undertakings were, and I use the judge's word, worthless. Actually, I think the immediate point I make here is that having dropped that point and accepted that their cross undertakings are worthless, given what Moylan and friend said about these two things being two sides of the same coin, it's a little bit difficult for him to continue to pursue his first point. As he was submitting to the court, well, what the court should do at first instance is look at the loss that is likely to be suffered and to require compensation under the cross undertaking, and in the light of that, consider the adequacy of the cross undertaking. If you've got a cross undertaking that is completely worthless, then as long as there is some serious risk of loss, then it's obviously inadequate. And at the very least, it rather takes the pressure off in relation to the first point, if the appellants have conceded, as they have, that their cross undertakings are worthless. But nonetheless, let me deal with the first point that they are still pursuing. This is the argument that, as they put it, Yodel hadn't put forward any credible evidence of loss if an injunction was to be granted. That is just an impermissible attempt to challenge findings of fact here. And in any event, it's hopeless, my lords, because there is ample evidence. There was ample evidence before the judge. And their criticisms of the evidence are completely misplaced. It's detailed and it's clear, and I'll take my lords to it. It's unsurprising that it's detailed and clear because, of course, what it's based on is work actually done on the ground, not for the purposes of court proceedings, but for the purposes of in-post JLL and Yodel deciding whether to go ahead with this plan, which involves, as the learned friend has told the court, spending a lot of money. And one thing that Mr. McCourt's evidence shows is a detailed and careful process, not a snap decision at all, based on a lot of forecasting and a lot of work to work out whether this was viable and how much it was going to cost. And ultimately, it's that material on which Mr. McCourt's evidence about the likely effect of an injunction is based. Now, I don't want to go back through all of Mr. McCourt's first statement because I know the lords have read it, but let me just identify the three types of loss that are identified there. And they're all forms of loss which would arise from the granting of an injunction. And the first is loss-making trading caused purely by the delay that an injunction would produce. This is the most obvious form of loss. It's loss that would be inevitable if there were an injunction granted, and it's purely as a consequence of the delay. So let me just explain that, because the hypothesis, of course, here is that an injunction might be granted, but we win at trial, so it's wrongly granted. And one result of that, if of course Yodel doesn't fail entirely in the meantime, but one result of that would be that Yodel's reorganisation that's currently being pursued and had been started in June at the first instance hearing, at the time of the first instance hearing, would be postponed for at least 6 months. Because as the judge accepted on the basis of the evidence, if there was an injunction over until after the conclusion of the trial, that might start in early November, that would involve postponement of the reorganisation, in fact, until January 2026 at the earliest, because of the impossibility of starting a process like that during the peak period. So, if there were an injunction, the reorganisation process that had started in early June would have stopped and been delayed until January 2026. Now, the mere fact of a 6-month delay would involve inevitable loss in the form of the further loss-making trading that would have carried on for 6 months, which would have had to be funded. Because under the injunction, only the ordinary course of business would be allowed, and that would basically mean continuing the business as it was. And that has been loss-making for years. And that would be loss that would clearly not have been suffered but for the injunction. Purely the result of the injunction, it would have stopped the reorganisation process being pursued for 6 months. And then, if the hypothesis is we win at trial, so we have to start it carry on with it, not in June 2025, but in January 2026. It's common ground that those losses could only be covered by more borrowing from JLL.
Which of the losses? Which of the paragraphs in his statement that address that first category of losses?
Particularly 42.
42.1 and 42.2.
Yes, and I'm going to come to that in a second.
Okay.
Because clearly, it's absolutely clearly going to be loss making, and it's going to be for at least 6
No,
months.
fine. Yeah, thank
so
you.
the next question that I'm coming to, my lord, is well, how does one quantify it?
I see. Thank
And
you.
that's where paragraph 42 comes in, because what Mr. McCourt does is to base his estimate, which ends up at 33 million, so 5.5 million a month, on the actual results for March and April 2024. He looks at it in two ways, but the more conservative in the sense of the approach producing a lower figure for loss is based on looking at the March and April results. So the actual results, and the reason he looks at March and April, as he explains, is at that point, which was before InPost had become majority shareholder of JLL, but at a point when the transformation plan was being discussed, as he explains, paragraph 27, the management of Yodel had started to implement whatever they could without integrating anything with InPost. So they'd taken the steps that they could without any integration, because of course the InPost hadn't yet become indirect majority shareholder. Now, so therefore, the loss that was suffered in March and April wasn't quite as high as it would have been if nothing had been done at all. But it accurately reflects what would have happened if there had been an injunction stopping any further progress of the organisation. And that's in particular Mr. McCourt at 42.1. So that is very clear, very reliable evidence that actually puts a fair figure on the likely loss. Some form of loss in the form of loss-making trading and the need to incur further debt was inevitable. But even the figure itself, the estimate of the figure, is very reliable because it's based on an actual outcome for March and April, which pretty well reflects what would be likely to have happened. It might be different, it might be different in either way, but it's a good estimate in my submission.
I mean, the counterfactual is depends on whether your plan is a good one, whether it's lower losses.
But no, Lord, in my submission, no, it doesn't, because this is delay. This is the result purely of the delay. The plan might, if pursued in January 2026, have been a complete disaster. That extra loss over those 6 months as a result of the loss-making trading would still have been incurred and would not have been incurred had there been no injunction.
Is that quite right? I'm not sure I've got my mind around this. So suppose your plan is a bad one.
Yeah.
They manage to prevent you implementing it for 6 months so that Yodel doesn't incur the extra losses that would arise from implementing your plan.
No, but they will, because Yodel will then implement the plan in January 2026. You'd have to hypothesise that Yodel and InPost came to a completely different view for some reason between now or June on the one hand and January 2026 to go down that road, because the hypothesis has to be that they're completely committed to this, and clearly they are, my client and InPost, because InPost is paying an awful lot of money into this. A lot of effort's gone into working out whether it's a good idea or not. And as of today, we're halfway through it at least. But even in June, we'd started it. Now, you have to assume that, therefore, in January 2026, if an injunction were wrongly granted, we carry on. Now, if for some reason that were a complete disaster, the delay wouldn't have saved any money. It would be a disaster whenever it was done. That's the reason this 33 million figure is so cast iron in our submission, because it's purely the result of the delay. Because what the appellants want to do is to get the court to order that the company has to basically do nothing but carry on as it was. And we know that carrying on as it was involves loss making, and it's not a flash in the pan. It's been loss making for years, and that's common ground. And so that loss making over that period will be entirely additional loss. And
It's all slightly theoretical, isn't it? Because it assumes that InPost will go on funding the company and will be willing to defer its plan for 6 months, or I think 5 months now, which if the injunction were to be granted, then InPost, who is funding the company at the moment, would have some hard thinking to do.
Absolutely.
And one can see it might decide to go on funding, or it might decide to pull the plug, in which case the company would be insolvent and cease to do business very quickly, or it might to try and think of some other arrangement.
Well, on the evidence, if InPost isn't prepared to carry on, the company will end up in administration.
Exactly.
Now, but that in itself will produce uncompensatable loss for Yodel and indeed for its creditors. And for a start, it would be a disaster for its creditors and possibly for the 3,000 or 9,000 if you include non-employed workers, employees who work in the business. But it would also inevitably cause loss to Yodel itself, because if there's an administration, the business will be sold out of administration. And inevitably, it will be less valuable if sold out of administration than it would if theoretically sold as a going concern. So the administration would, A, crystallise an enormous loss for creditors, we'll come on to this, but B, also cause loss for Yodel. So my lord is, with respect, I would submit, absolutely right. My 33 million and loss arising from delay presupposes that, yes, InPost does carry on funding, and so there is in January 2026 a resumption of the reorganisation. But the alternative, the only basis on which that's not likely to happen, is even worse, because it's administration. So, yes, but it doesn't help the appellants, is the short answer I would respectfully suggest to that.
Maybe so.
Now, my learned friend then, at this point, made an attack on the basis for Mr. McCourt's assessment as to the likely outcome of the reorganisation. This is the 2 plus 10 plan. Now, I can take my lords to it and defend it, and I will perhaps briefly, but the first point is it's totally irrelevant, because the loss, the 33 million, does not in any way depend, as I've just submitted, on the success or otherwise, or the likelihood of success of the plan. But even if it did, the judge was perfectly entitled to find, as he did, that there was a prospect that the plan would restore the company to success. Now, we can look at 10.2, 2 plus 10. The point of 2 plus 10, of course, is it's based on the first 2 months of actual trading in 2025 and then forecasts for the next 10 months. But of course, the forecasts are based on the work done on the reorganisation plan. I'm afraid I've got this in. I'm sorry, I've prepared from the supplemental bundles in full because I did my prep before the core supplemental bundle came into existence. But
if you give us the page numbers, we can see.
If I can try and use the internal page numbers, if that.
Well, no, actually, could you give us the bundle page numbers? Because that's what we've got on ours in the core supplementary.
The supplemental bundle numbers, it starts at 2265.
Yes.
And Moylan is actually right. We've only provided the extract, but we've explained why. It's highly commercially sensitive. This is a document that explains a plan which involves forecasts based on the expectation of renegotiating contracts with a number of both customers and suppliers. And so we clearly couldn't put all this into the public domain before we'd started those negotiations.
Yes.
And therefore we've had to, as one sees, redact a few parts of even what we have put in. Although that's often because it's identifying the facilities which will be shut, which of course we can't do until we have the consultation with the relevant employees, apart from anything else. So there are good reasons why it's not complete, but there's more than enough to see that this is an extremely careful and detailed plan. And what it does, if one goes on to 2267, most importantly, is to actually set out a forecast as to the consequences for EBITDA, as my friend shows the court. That hopes to break even that hoped then to break even by July, and then turn a small monthly profit by the end of the year, end of 2025. I noticed the time, Lord. Sorry, I shouldn't have set off on this probably. That's a mistake on my part. So,
Should we stop now?
right, well, shall I pause there? But just first, we do have instructions that in post SA, that's the listed company that's right at the top of the group, will provide a guarantee. There may be some minor amendments necessary simply because it's a different guarantor, but in substance the same. And we'll make the amendments over the short adjournment so we can provide an absolutely correct document.
I think we'll stop there anyway and come back to this
Thank you. Sorry.
at 2. No, not at all. At 2 o'clock. So we'll start again at 2 o'clock.
Court rise if able to.